our Honorable Senator Robin Padilla, our esteemed panelists will be introduced later. Ladies and gentlemen, good afternoon. In the last 25 years, the Philippines has witnessed impeachment proceedings against 5 high-ranking officials. President Joseph Estrada in 2000, impeached by the House of Representatives on charges including bribery, graft, and corruption. Ombudsman Merceditas Gutierrez in 2011. The Senate convicted and removed him from office in 2012. Commission on Elections Chairman Andres Bautista, 2017, impeached over allegations of unexplained wealth. He resigned before the Senate could conduct a trial. And Vice President Sara Duterte in 2025, excesses such as political instability and institutional dysfunction. Impeachment ensures that high-ranking officials remain accountable for corruption, abuse of power, and violations of the Constitution. A high number of impeachment cases may reflect robust democratic framework where misconduct is actively challenged. However, they may also destabilize the government, making it difficult for leaders, including misuse of public funds and threats against the President. Her Senate trial is pending.
Where impeachments are used as a tool to remove opponents rather than address legitimate.
Excessive impeachment proceedings may indicate deeper issues such as political instability and institutional dysfunction. Impeachment ensures that high-ranking officials remain accountable for corruption, abuse of power, and violations of the Constitution. A high number of impeachment cases may reflect transparent and based on evidence. They boost public confidence in democratic institutions. However, if impeachment is used as a political weapon, it can lead to distrust in government and create divisions among citizens. In healthy democracies, impeachment upholds the rule of law by holding officials accountable. In weaker systems, frequent impeachment attempts may indicate political weaponization. The significance of having many impeachment cases depends on how they are used. If impeachment is legitimately used, it strengthens democracy, accountability, and governance. The academic community plays a critical role in ensuring an informed, objective, and evidence-based impeachment process. Scholars, universities, and research institutions contribute to legal analysis, public discourse, and historical documentation. Their role is crucial in promoting fairness, democratic stability, and public trust. During impeachment proceedings, we act as neutral bodies that assess whether impeachment proceedings are legally and ethically justified. Thank you, everyone, for your time in this important forum to listen, understand, or participate.
Thank you, Dean Berberabe. This forum features 2 panels, the first on emerging issues in impeachment and the second on the Duterte impeachment in particular and lessons from the past. To introduce our panelists for the first, please welcome Professor Fina Bernadette A. de la Cuesta Tantuico, Secretary of the Malcolm Foundation and member of the UP Law Faculty. Professor Tantuico.
Good afternoon. It is our privilege to be joined by a diverse panel of experts who can speak from an academic and practical level about emerging issues in impeachment. So my task this afternoon is to give you a brief profile of each of our speakers. First off, we have none other than the Honorable Franklin M. Drilon, former Senate President and member of the Estrada and Corona impeachment courts. He was a former member of the Senate of the Philippines with the distinction as its longest-serving member. He also served as Senate President for the 10th, 11th, 12th, and 13th Congress. Senator Drilon participated in the impeachment trials of former President Joseph Estrada in 2000 and former Chief Justice Renato Corona in 2011 as a member of both impeachment courts. Prior to his service in the Senate, Senator Drilon served as Secretary of Labor and Employment, Secretary of Justice, and Executive Secretary of Presidents Corazon Aquino and Fidel V. Ramos. He was also formerly the managing partner of Accra Law. He graduated from the UP College of Law in 1969 and placed third in the bar exams held in the same year. In 2014, he was conferred the degree of Doctor of Laws honoris causa by the university. Our second speaker is none other than the Honorable Conchita Carpio Morales, former Associate Justice of the Supreme Court and former Ombudsman. She served as an Associate Justice of the Supreme Court from 2002 until 2011. She is the ponente of the Francisco versus House of Representatives case, the 2004 Supreme Court decision that barred the impeachment complaints against then Chief Justice Davide. Soon after her retirement, she was appointed by former President Aquino to be the fifth ombudsman. She obtained her Bachelor of Laws in 1968 from the UP College of Law. In 2016, she was conferred the Doctor of Laws honoris causa, recognizing her 28-year service to the judiciary unmarked by any accusation of impropriety, and for being herself the measure of integrity in government service and the face of courage and daring determination, of competence and independence, and one of resolutely intolerant of corruption. In 2016, Ombudsman Carpio Morales was one of the 6 recipients of. Our third speaker was a member of the 1986 Constitutional Commission, the Honorable Rene V. Sarmiento. He was a member of the 1986 Constitutional Commission, which drafted the 1987 Constitution. She is the current Program Director of the UP Law Center's Competition Law and Policy Program. She previously served as Dean of the Manuel L. Quezon University School of Law and the first Executive Director of the Philippine Competition Commission. She previously served as a bar examiner in political law and public international law for the combined 2020 to 2021 bar exams. She currently teaches constitutional law in the UP College of Law and has lectured at the Angeles University Foundation and the Ateneo de Manila University School of Law. She obtained her Bachelor of Laws degree from the UP College of Law in 1995. She placed 7th in the 1996 bar examinations. She obtained her Master of Laws degree from Northwestern University School of Law in 2010. The last speaker in our panel, in this first panel, is Professor Theodore Te, also from the UP College of Law, the former spokesperson of the Supreme Court. As a lawyer from the Free Legal Assistance Group, Professor Te notably served as counsel for Leo Echegaray, as well as Rappler founder and Nobel Peace Prize recipient Maria Ressa. He graduated from the UP College of Law in 1990 and obtained his Master of Laws degree from Columbia Law School in 2012. He currently teaches evidence and heads the college's clinical legal education program as Director of the UP Office of Legal Aid and the Clinical Head of the Civil and Political Rights Clinic. Both panel discussions today will be moderated by no other than Assistant Professor Paulo Tamase, the Assistant Secretary of the Malcolm Foundation. He is an Assistant Professor of the UP College of Law who teaches constitutional law, administrative law, public officers, legal history, and comparative law in the UP College of Law, where he also serves as Assistant to the Dean for Academic Affairs. He obtained his Bachelor of Science in Business Economics magna cum laude from the UP in 2012 and his Juris Doctor from the college in 2016, graduating as valedictorian and serving as chair of the Philippine Law Journal. He obtained his Master of Laws in 2022 from Yale Law School, researching on comparative administrative law and comparative and constitutional law and economics. Ladies and gentlemen, with that formidable roster of panelists, I am confident that we will all benefit from a productive and enlightening afternoon. Thank you very much.
Thank you, Prof. Fina. May I invite our 5 panelists for the first panel of emerging issues in impeachment to please come up the stage and join us here. Agreeing to join us on a very short notice. We transmitted to them a list of questions on emerging issues that we would like to discuss for today. But before we get to those 5 questions, we had invited them to provide first opening remarks if they wish to. We understand that most of them do not want to give initial remarks, but that Commissioner Sarmiento did prepare a short presentation for all of us today. So unless anyone else would like to begin, then may I call on Commissioner Sarmiento to present.
Negotiating with the NPA and DF for many years. Our Justice Carpio Morales, our 2 professors from the UP College of Law, Professor Gwen, Professor Ted, my colleague in the Free Legal Assistance Group, my co-panelist of the second panel, and of course our beloved Dean of the UP College of Law, Dean Darlene. She's the darling of the College of Law. To the students of law, to lawyers, representatives of the House and the Senate, Senator Robin Padilla, guests, ladies and gentlemen. May I go direct to the point? In the ongoing national conversation on impeachment, 3 issues emerge. And what are these? Number 1, can the Senate of the 20th Congress continue the impeachment trial that has started during the Senate of the 19th Congress? Number two, can the Senate forthwith proceed with the impeachment trial even during recess? And number three, can the President call a special session at any time? My answer to issue number one is yes. This has been addressed in the case of Pimentel Jr. versus Joint Congress Committee to canvass the votes for the President and Vice President, a 2004 decision, where our beloved Justice Carpio penned her separate concurring opinion. Petitioner Aquilino Pimentel Jr. asked the Supreme Court to annul the proceedings before the JCC because it has become functus officio because of the new Congress. But petition was denied by the Supreme Court in an en banc resolution. The Supreme Court making a distinction between legislative function and non-legislative function. The Supreme Court saying that it has not become a functus officio insofar as non-legislative function. Meaning outside of legislation, it has a continuing function. It could be convening as a canvassing board. It could even be serving as an impeachment court. And a separate concurring opinion, our esteemed Justice Carpio Morales, citing the extensive deliberations in the 1986 Constitutional Commission, in the exchanges between Commissioner Maambong, a former lawmaker, and Commissioner Davide, a former lawmaker. She wrote that again, repeating the legislative and non-legislative function of Congress. So yes, it has become functus officio insofar as performing its legislative functions, but not its non-legislative function, which is continuing. My answer to issue number two is yes. Can the Senate forthwith proceed with the impeachment trial? Ito po ang mainit na pinag-uusapan po ngayon sa ating lipunan. Further proceed, or in the Tagalog version of the 87 Constitution, dapat agad isunod, is a novel addition in the 1987 Constitution on impeachment, not found in the 1935, not found in the 1970 Constitutions, not even in the U.S. 1787 Constitution. In ordinary meaning, as constitutionally interpreted, it means right away. It means immediately. Walang patumpik-tumpik. Walang alinlangan. Gawin kaagad. The records of the 1986 Constitutional Commission.
Walang alinlangan. Gawin kaagad. The records of the 1986 Constitutional Commission are bare. When forthwith proceed was introduced, it was part of the committee report number 17 on accountability of public officers and submitted for plenary discussion on July 26, 1986. Yours truly was the acting floor leader when this committee report, which includes forthwith proceed, was presented on the floor. Absent discussion on forthwith proceed, its immediacy and urgency can be drawn from the intent of the framers of the Constitution, from the exchanges of the members of that commission on the time-compelling significance of impeachment. Commissioner Regalado Maambong, citing, quote, Power of Impeachment Guide to Congress, said that impeachment is not personal punishment or vendetta, but primarily to maintain constitutional government. The President is called to account for abusing powers which only he possesses that have a tendency to subvert constitutional government. And it would include other impeachable officers. Commissioner Blas Ople, in his poetic language, his usual poetic ornate language, stated that impeachment is a sword in the scabbard. It is as good as a sword drawn. It is not a constitutional decoration or a tinsel, but a powerful check on the presidency. The prospect of an impeachment trial, according to him, caused then U.S. President Richard Nixon to resign. Commissioner Felicitas Aquino inputted that impeachment is in the nature of an exemplary act by which the state infuses the highest sense of responsibility to public service. Finally, Christian Monson said that it is a deterrent and added that President Marcos Sr. exerted all efforts at that time to defeat the impeachment proceeding and the subsequent calling of a snap election at the time may have been influenced to some extent by an attempt at impeaching him. We go to question number 3. Question number 3 is, can the President at any time call a special session? My answer to issue number 3 is yes, is also yes. The President may at any time call a special session of Congress. The 1973 Constitution says the Prime Minister may call the National Assembly to session at any time, quote, to consider such subjects or legislation as he may designate. The 1987 Constitution provides that, quote, the President may call a special session at any time. The Philippine experience is that President Elpidio Quirino and President Gloria Macapagal Arroyo, in separate proclamations, called a special session of Congress. Quirino called for a special session to address insurance loss concerns in the Philippines. President GMA to address the VAT issue at the time. In the U.S., the President has called a special session of Congress to tackle issues related to war, economic crisis, ratification of treaties, and others. It's more broad in the U.S. when the President calls for a special session. May President BBM, our wish, call a special session of the Senate to start the impeachment trial. Of the 3 issues, the first best option to me, is forthwith proceed. Reasons were already given. The second best is a special session. And the third best is the new Congress continuing the impeachment trial if it is not done before Congress adjourns on June 13, 2025. In the light of these intractable emerging issues, I humbly suggest a national day of prayer to beseech God Almighty for guidance and wisdom. Benjamin Franklin introduced the idea of prayer in the sessions of the 1787 Constitutional Convention, realizing the importance of prayer, God's powerful role in the life of nations in shaping their destinies. The same reason why George Washington, in his oath-taking as the first president of the United States, added in the presidential oath, "So help me God." And thereafter, future presidents all over the world included "So help me God" and their swearing-in ceremonies. Well, this may be difficult times in our country. The impasse on this issue of impeachment impacts our country politically and economically. The soonest this issue is put to rest by a wise and bold choice of any of the options I have mentioned, the better for our country to become wiser, stronger, and God-praising. Yes, the worst of times can be the best of times. Maraming salamat po.
Thank you, Commissioner Sarmiento. The 5 questions we presented to our panelists via email are actually the following. First, may the Senate hold the impeachment trial even if Congress is on recess? And can the President call a special session? The second is, may the impeachment trial carry over from the 19th Congress that impeached the Vice President to the 20th Congress? The third would be, would the Vice President's resignation result in the cancellation or pre-termination of the impeachment trial? The fourth is there a standard of evidence in impeachment trials, or should there be? And the fifth is, if a case is brought to raise these questions, may the Supreme Court step in, and more importantly, should it? So we hope to discuss all of these 5 important questions in the short time that we have. And so let me begin immediately with the first question, on may the Senate hold the impeachment trial even if Congress is on recess? We heard from Commissioner Sarmiento, who talked about the difference between legislative and non-legislative functions. I wanted to ask first for the rest of the panel what their thoughts would be on this. Senator Dulon would be a very interesting reference because of his experience in the Senate.
Thank you very much. Yes, I have been a senator judge twice in my life already. But anyway, first of all, let me greet a colleague in the Senate, Senator Robin Padilla, who will be a senator judge come and impeach what's impeachment trial. So the first question is, can the president, can an impeachment trial take place during the recess?
Yes.
Okay. The answer is the impeachment court can only be constituted in a proper referral when the Senate is in session. If the Senate is not in session as it is today, this impeachment court cannot constitute itself because the reference of the impeachment complaint is to the Senate. And therefore, the Senate, in a formal session, will refer this to the impeachment court. So the impeachment court has to be created upon a session of the Senate. Can the President call a special session? Yes, the power of the President to call a special session is not limited by anything. If it is the theory that the impeachment, the President can even call a special session so that the impeachment trial can take place. And if the President can call a special session to consider legislative measures, even the renaming of a street is a legislative measure which we can take up in a special session. How much more an impeachment trial? In my view, an impeachment trial can be called by the President in a special session. What's the next question?
I think we can stick to the first question first, Senator.
Okay. Thank you very much.
Thank you, Senator. Justice Carpio Morales, your thoughts?
The Senate is in recess with respect to its legislative functions. Impeachment is not a legislative function of Congress. The impeachment provisions fall under the accountability provisions of the Supreme Court and not under the legislative department provisions of the Supreme Court. So, given that, I believe that impeachment cannot be constituted during recess. This does not mean that during recess, the Senate cannot call for special session. But this is prescribed by so many limitations, including only on urgent legislative matters, and given that, among others, and given that impeachment is not included as among the reasons why special session can be conducted, my conclusion is that no, impeachment proceedings or this impeachment trial cannot be conducted during recess. Thank you.
Thank you, Justice Carpe Morales. May we hear from Prof. De Vera and then Prof. Te first.
Thank you, Prof. Tomase, and thank you to our co-panelists for this afternoon. I tend to agree with the view that's already been presented, that while the Senate is in recess, they will not be able to constitute themselves into the impeachment court. However, there's another question that perhaps we can discuss in the second round, which is, are there preparatory steps that may be undertaken while the Senate is in recess, so that if they do decide immediately upon resumption of session on June 2 to constitute themselves into an impeachment court, then trial can proceed forthwith. Noting that in the two previous impeachment trials, of course we can ask our Senate President here, shortly after the transmittal of the articles of impeachment, I think within a few days, the impeachment court was constituted and subsequently trial ensued. Thank you.
Prof. Te?
Thank you. Yes, I share what is now apparently a consensus that the Senate cannot hold the trial during the recess, simply because when the articles were transmitted, the Senate had already gone on recess without taking steps to convene the Senate as a court to draft up the rules of impeachment, even if they were simply to adopt the previous rules of impeachment that had been used by the Senate before. And so, yes, I would share that consensus, but I also agree with Professor Gwen that during this break, during this recess, the question of whether the Senate can take certain preparatory steps towards making the trial, any trial that may happen once the recess ends, perhaps more expeditious, whether that could happen, I think that is not foreclosed as far as the Senate is concerned.
Thank you, Professor Te. So if I can ask our Senator Drilon or Justice Carpe Morales or our colleagues in the faculty here, there is, however, this view from other academics, other scholars who think that delaying the impeachment to when session resumes in June 2 might frustrate both the word forthwith in the Constitution and also principles of accountability. And I think I was in a conversation with Justice Vivi Mendoza on this, where he says that the great battlefield of constitutional law today is the meaning of the word, or is the word forthwith. So I wonder what your thoughts would be in relation to that. Would delaying impeachment actually result in frustrating accountability?
You know, to resolve that question, I have asked the President to call a special session. Even if you don't include as an item in the special session the impeachment trial, the Constitution provides that the Senate that the impeachment trial shall take place forthwith in the Senate. So even when as a reality, when the President calls the Senate into a special session, the first item on the agenda is consideration of the impeachment complaint filed by the House. And that will be referred to the impeachment court. And then you start the impeachment trial. So I strongly believe that when the president calls for a special session, the impeachment trial immediately takes place because of the mandate of the Constitution.
Thank you, Senator Delon. Justice Carpio Morales.
According to Black Dictionary, forthwith means immediately, at once, but it also considers reasonable delay.
Some of the senators, current senators, are running for re-election. To me, these constitute circumstances that can abate the use of the word forthwith. Thank you.
Thank you, Justice. Prof. Gwen, Prof. Ted.
Thank you, Justice. My understanding of the word used in the Constitution is not just immediately, but also a sense, as Justice Carpio Morales pointed out, reasonableness, that it means avoidance, undue delay. So that if the action of the Senate is not animated or motivated by imposing undue delay in commencing the proceedings, I think they would well be in compliance with the constitutional mandate to proceed with the impeachment trial forthwith.
Thank you. Prof. Ted.
As litigators would know, often when you go before a court and ask for time, the court will usually ask you if you're trying to delay the proceedings. So the question of forthwith, I think, also goes into motivation or intent, or things that you can foresee or cannot foresee. So I would agree with Justice Carpio Morales that while it would mean by ordinary meaning, immediately, but it also takes into account circumstances. It also takes into account reason, and it takes into account things that the Senate cannot control, like the recess. The objective circumstances being that the transmittal was made on the last day of the session, and they had gone into recess before they had referred it to the impeachment court. Therefore, that may constitute, even though there is a span of time that intervenes, that may constitute reasonable delay, as it were, and would not frustrate the meaning of the word forthwith.
Commissioner Sarmiento, I'd like to ask if you have a response to these views.
I see the wisdom of the responses of Senator Frank, Justice Carpio, and my co-panelists. But I mentioned in my presentation, this is a very novel addition in our history as a people, not even found in previous constitutions and many constitutions of the world. Very unique provision in the Constitution. Traditionally, yes, on recess cannot be, unless the President calls for a special session. But this is a novel addition in the Constitution. And in the light of the intention of the framers of the Constitution, na walang patumpik-tumpik, umpisan kaagad. Because it's a time-compelling, significant activity in our country. Accountability, checking abuse of powers, etc., etc. Then, to me, I would say that regardless of the recess, time impeachment trial should begin in the light of this constitutional provision.
Yeah. I cannot accept the proposition that simply because the senators will be campaigning such an important and critical constitutional duty to constitute itself as an impeachment court and try the impeachment complaint can be deferred. Firstly, the Constitution says shall be tried forthwith. And we give ordinary meaning to ordinary words. Forthwith means immediately. And it is my respectful submission that the campaign period is not a valid reason to postpone. And in fact, there should be no circumstance to justify a deferment because the Constitution mandates the performance of a constitutional duty forthwith. The only reason why we need a special session is the formal referral of the impeachment complaint to the impeachment court.
Thank you, Senator. Yes.
Professor Tamase, may I make a follow-up? We have in constitutional law the doctrine of constitutional supremacy. All laws, all regulations, all contracts have to yield to the supremacy of the Constitution. I think all lawyers would know that doctrine. So if recess is a legal provision, it is a provision in the rules of the Senate. They have to yield to the command of the Constitution about forthwith proceed.
Thank you, Commissioner Sarmiento. I understand it may have also been in line with innovations in the 1987 Constitution to make it.
To preserve constitutional government, to preserve the order in our country, to avoid chaos. So to me, the lowering is very relevant to this forthwith proceed provision in the Constitution.
Thank you, Commissioner Sarmiento. I think the reason why, Justice, thank you. Would you have a response to this question? I think the points of Commissioner Sarmiento. Thank you, Justice.
I'm going to respond to the fact that, wait, the Hello Garcia case, Hello Garcia, I'm sorry. The Supreme Court said that the Senate is a continuing body. It's a continuing institution. But the discharge of its day-to-day normal functions, it is independent of the predecessor. In other words, it's not bound by what the preceding Congress, Senate did. So any unfinished matter can be considered as if it's set for the first time. Thank you.
Thank you, Justice Chip. I think that brings us to the second question, which ties into the urgency of the impeachment or the sense that the Senate should proceed immediately. Can you please flash the next question? So the second question, and I think it ties into this concern that if the Senate does not meet now, when it is on recess, then there might be a frustration of the impeachment trial, because another question that keeps coming up is that will the impeachment trial carry over from the 19th Congress to the 20th Congress, when I think I understand from Garciliano and the older case of Arnott, the Supreme Court said that the Senate is a continuing body, but then we have this more recent case of Balag where the Supreme Court now says that Congress or the Senate's business does not continue beyond a Congress. So your thoughts, Justice Carpio Morales or Senate President Drilon, on this?
Well, I'm not the Supreme Court, but I maintain my position.
Thank you, Justice. Senate President Drilon.
To me, this is an open question. Can the impeachment complaint filed in the previous Congress be continued when the new Congress comes in and the new impeachment court comes in? A lot of questions have heretofore been not answered. Yes, there is a view that the Senate is a continuing body and therefore can continue to hear the impeachment complaint. You know, there are a lot of opposite arguments can be raised, as in this is not in the nature of a investigation by Congress, but you know, it's an investigation of the impeachable offenses allegedly committed by the Vice President, and therefore the question is, can the question of the mandate of the present Congress when it expires, etc. So this is an issue which I don't pretend to be able to answer right off the bat, and maybe the colleagues of Chit here in the Supreme Court can answer that question better. But it is a question which has not been answered, and that is why I hope that this can be raised so for us to be enlightened.
Commissioner Sarmiento, would you have a response to this question?
Professor Damasen, so far as that question is concerned, you have the concurring and dissenting opinion of Justice Carpio. In the case of Garciliano versus House of Representatives, what was his concurring and dissenting opinion? Insofar as all other matters and unpassed bills are concerned, deemed terminated. And he was referring to legislation. So that, with respect to non-legislation, the case of the one I mentioned, Pimentel versus House will come in. Impeachment is non-legislation. So therefore, if it has been started in June 2, 2025, it has to continue when the 20th Congress resumes or opens its session.
Thank you, Commissioner Sarmiento. Professor Devera, Professor Te, just perhaps to add a little more context to this question, and to be, just to present a devil's advocate position, I think the position of some is that the Senate terminates on June 30, not just from a constitutional standpoint, but also from a democratic standpoint. By the time you have people selecting a new Senate with probably different priorities or policies, does that change any answer that you may have with regard to this question? Or how would you respond to this question about impeachment crossing over from the 19th to the 20th Congress?
As Senate President Drilon mentioned, this is an open question. We don't want to prejudice a consideration of that question should it reach the Supreme Court. But at the moment, I think we have three theories on this point. The first is that it may continue into the 20th Congress for the reason that Commissioner Sarmiento had mentioned. The second is it may continue into the 20th, but it will be up to the 20th Congress, specifically the Senate, on whether they will take it up from where the 19th Senate had concluded its work, or if they will restart. And the third, of course, is that it simply does not continue into the 20th Congress for the reason which you stated. So if we look at members of the Senate and members of the House as duly elected representatives of the people, then certainly we must respect the views that may be brought into the question by those who will be duly elected in the 20th Congress, which would then, of course, it's not just a change in the composition. I had heard this as well on a number of news coverage, that there's the view that it's simply a change in composition which should not affect the continuous conduct of the trial, in the same way that, for example, the Supreme Court does not conclude a consideration of any case just because there has been a vacancy that has been filled with a new member. But I think it's very different from a legislative body, which is a representative body, and we should respect, for example, elections are coming, and we respect the vote that each one of us will be making on that day, and that may certainly include a vote on which representative I wish to elect and his view on this particular question. So I think those are the three sort of theories that we have here. But from a strictly legal perspective, we put together what we have based on Supreme Court decisions. It looks like it can continue into the 20th Congress, but the 20th Congress, particularly the Senate, will then have to consider whether it will continue or if it will start anew, which would mean constituting itself anew as an impeachment trial, reconsidering the rules for the impeachment trial, because none of the work of the previous Congress has any conclusive effect on the succeeding one.
Before we go to Professor Te, Senate President.
Let us remember that the Senate is not the impeachment court. The Senate is completely a legislative body. The impeachment court, as we call them, is sui generis, a class of its own. So these are questions which are not easily resolved. And the issue that just like the appellate courts, it can continue to function. You know, you could also make an argument against this proposition that this is not a court, this is not a body which is constituted by law, but it's constituted by a complaint of the House of Representatives, which, by the way, whose mandate would have also expired when this Congress expires. So does the impeachment complaint continue to be valid with the impeachment, with the impeachment complaint authors have lost their mandate because their terms have expired? Marami pong hindi masagot dito. And kaya maganda naman nandito si Senator Robin Padilla. Siguro yung papakinggan niya rito, dadalhin niya sa Senado po natin yung panahon. Salamat po.
Thank you, Senator Dillon. Professor Tab, before you answer, so I understand the hesitance to take up a position in a very difficult open question. I think for lawyers, the difficulty also comes from the fact that impeachment is not really a strictly legal proceeding, and therefore, you know, the idea that law can rise above politics might not be as strong as, let's say, democratic accountability or legitimacy that really goes into the question of impeachment. So if I can, you know, tease you a bit into taking a position, all difficult questions that the court decides are open questions before they get to them. Would you have any particular position on this?
I was about to make the analogy that Senate President Dillon made, that when the impeachment court has been constituted, it is not the Senate. In the same way that the Presidential Electoral Tribunal, once constituted, is not the Supreme Court, even though it is composed of all the members of the Supreme Court. It acts as the Presidential Electoral Tribunal with a different set of rules, with a specific mandate, and therefore, as far as, you know, regularity of the schedule, the Senate acting as an impeachment court may not actually be bound by that calendar of, you know, session, adjournment, recess, session, adjournment, recess, for purposes of legislative work. And so I would, well, since you teased me into taking a position, I would probably say that if it is based on that particular characterization of the Senate having been constituted, and I think this is the qualifier I would make, if it had been constituted as an impeachment court while the 19th Congress is in session, and once the 20th Congress comes in, the impeachment court will still stand, having been constituted already, because it is not the Senate acting as a legislative body. The question now of how many members and which members, that is now the difficult question, because practically half the Senate will have their terms ended. There will be new senators. There will be new senators coming in, and so that would have different implications. But I think that would be my position.
I think it's also worth noting, especially for the law students and lawyers here, and my own law students, that, you know, while the word impeachment court does not really appear in the text of the 87 Constitution, you know, the practice of the Senate in the last two impeachment trials has really seemed to indicate it as sort of an independent creation or independent body. You know, legislative precedent is one of the ways we understand the Constitution, and so the idea, for example, that you would have a separate oath indicate that the Senate transcends to a higher political body than just the typical legislature. Senator Dillon.
Yes. Just a question occurs in my mind. An impeachment court is not an ordinary government agency. Suppose the politicians which constitute the impeachment court would make a political decision and say, we will not follow what the Supreme Court says. Can somebody tell me if you can declare them in contempt? In other words, what I'm saying is, there are really a lot. This is one question that bothers me. The impeachment court is not an ordinary government agency. It is a court created by virtue of an impeachment complaint filed by Congress. We say that the impeachment court is different from this, is not the Senate. So can the impeachment court refuse to follow the ruling of the Supreme Court? And if it does, what will happen?
Justice Carpio Morales.
I think whatever the impeachment court does is a political question. The Supreme Court would not take that up. That's my opinion.
I think that's supported also by the practice of the last impeachment, where the Supreme Court did order the non-disclosure or prohibited the disclosure of the bank accounts of Chief Justice Coron, and then the Senate voluntarily complied by you voted on the decision to just to not open it. So it might have might be a signal on the part of the Senate to still assert control over the process. Commissioner Sarmiento.
May I just go back to the open question that was mentioned by Senator Frank, whether it is a continuing body or not. Well, originally, this idea of impeachment was drawn from the Greek experience, borrowed by the English system and perfected by the U.S., and then borrowed by us from the U.S. Now, meaning the U.S. experience has persuasive impact on rulings of the Supreme Court and our legal and judicial experience. Now, in one case, the case of the impeachment of Judge John Pickering, the impeachment articles were submitted on the last day. 7th Congress. The 8th Congress continued the trial of Judge John Pickering. In other words, learning from that experience, pwede pala na ituloy ng panibagong Kongreso yung naumpisahan na under the old Congress.
That's a very interesting perspective, Commissioner Sarmiento. Are there any last thoughts on this question from our panelists? Justice Carpio Morales.
Yes, why not? The next Congress can take over, continue, but as I said, it can also be understood to mean that it is as if the matter has been presented for the first time.
Yeah, that's also possible. Prof. Gwen?
I think the emphasis here is so many of these questions are really addressed to the Senate, because the language of the Constitution is it has the sole power to try the impeachment case. So I think observing that constitutional language means the Senate has to consider very carefully how it will proceed, because it's also not bound by any step that it had taken in the previous impeachment trials. That's the first point. The second point is, as you had pointed out, the 1987 Constitution does not carry the words impeachment court. In fact, the specific provision addresses itself to senators. It says that the Senate has the sole power to try impeachment cases, and when the Senate sits for that purpose, it is the senators who take the oath or affirmation. And that's basically the constitutional requirement as far as the Senate is concerned. That is why I think there's a wide discretion on the part of the Senate with respect to the actual trial of an impeachment case.
And I think, taking with what Justice Carpio Morales said, that the Senate acting on this as a political question, then it also raises how, unlike the typical case where we have the Supreme Court informing us of how to conclusively read the Constitution, the Senate might actually weigh in more heavily on this point, whether it will decide to continue the impeachment trial.
Well, not to monopolize the conversation, but there are just two interesting points.
Yes.
Based on what you've shared. The first one is, in the U.S., based on their practice, there's that case of Nixon versus U.S.
Yes.
That's Judge Nixon
And for his impeachment, I think based on even an earlier impeachment case, what the United States Senate had done was to actually constitute a commission for purposes of taking in evidence, and that commission would render a report to the Senate as a whole, so that the senators can continue with their legislative work. Of course, in that particular case, the U.S. Supreme Court refused to rule on whether that was not unconstitutional, because they consider it as a non-justiciable question. Of course, in our own jurisdiction, we've resisted adopting that view that had been taken by the U.S. Supreme Court, and our decisions say that there are questions related to impeachment that may be considered as justiciable, particularly if there are standards that are provided in the Constitution against which the validity of a particular conduct can be assessed by the Supreme Court. So, so many questions arising from this particular case.
Thank you, Prof. Gwen. If we could...
That's why I suggested a special session. The impeachment court is constituted, the trial takes place, and finish it before the term of this Congress expires. So all these questions will not come to fore, because it will become academic with the decision, which I'm sure can be rendered before Congress expires. There are a lot of questions that will be raised here, and I don't know when it will be resolved.
That's right, Senator Dillon. So, you know, the difficulty with these open questions could have been solved if the President called a special session.
That calls for the conduct of trial, full trial up to its conclusion under the 9th Senate, on the assumption that there would be no difficulty presenting evidence on the part of the prosecution and on the part of the defense.
That's right, because the last impeachment trial also took around 5 months before it finished. And you know,
yeah, it can be finished. I have gone through it. It can be finished, because the senators would not want to be bogged down there. They would want to decide it expediently. There is nothing that prevents the impeachment court or the Senate from meeting from 8 o'clock in the morning to 8 o'clock in the evening. And, you know, we have gone through it. We would hold sessions, impeachment trials for hours, 10 hours sometimes. So, but because of these many difficult questions that will arise, if you allow the impeachment trial to spill into the next Congress, I thought that the best solution is just call a special session, then hold the impeachment trial forthwith.
Thank you, Senator Dillon. Justice Carpio Morales, as
Just
a last
want to
point.
put on record that Senator Robin Padilla is nodding his head. So you have a supporter.
Thank you, Justice Carpio Morales. If I can...
Just to add to Senate President, actually you were having a conversation earlier, and even from a litigation perspective, you were thinking that that would be the, well, there are already pending petitions today, but that would be the neatest if the entire proceeding could be completed within the 19th Congress.
Thank you, everyone. If we can move on to the third question, which is itself quite controversial. There have been views that the Vice President's resignation will result in the cancellation or pre-termination of the impeachment trial. And I think those views are informed by past impeachment practice. The resignation of President Estrada resulted in the termination of that impeachment court. The resignation of Ombudsman Mercedes Gutierrez, Andy Bautista resulted in trial not proceeding. But we also have quite recent practice from the United States where, because of the disqualification consequence or question, their U.S. Senate decided explicitly to push through with trial even if President Trump had already resigned by that time. So your views on this question?
This one is clearer. there are two consequences of there are two issues which the impeachment court will resolve. Number one, the issue of dismissal from office, and second, perpetual disqualification from holding public office. The resignation will make the first question academic, but the second issue is valid, perpetual disqualification from holding office, which will justify or which will provide basis for the continued trial in order that a decision can be rendered on the second issue. This issue, however, would have to be addressed to the impeachment court. In other words, it becomes a political issue and question whether or not, political in the sense of politics, whether or not the impeachment court will continue and continue to hear the case in order to rule on the second issue, which is perpetual disqualification. In the past, the impeachment court simply said, enough, ayaw na namin, uwi na kami. So wala na. So theoretically, the impeachment court can continue and decide on the second issue. But that's in theory.
Senator President Dillon, before I go to the other panelists, I think your experience here would be very valuable since you're the only one in this room who has decided an impeachment trial, especially the one in 2001, where the Senate decided to terminate the trial once President Estrada stepped down from office. Would you be able to share to us the reasons why the Senate decided to pre-terminate the trial instead of continuing to that question of disqualification?
Well, this is the impeachment trial for President Estrada.
Yes, the 2001 impeachment.
Well, the EDSA DOS made it academic. Theoretically, we could have continued with the impeachment court, in theory. But given the political situation at that time, I don't think it made sense for us to continue the impeachment court. We could have argued that the impeachment court should continue to exist to tackle the second issue, but we, under the circumstances then, we said no more, enough.
Probably highlighting also the very political character of the exercise. Thank you, Senate President Dillon. Our other panelists, would they like to weigh in on this question? Commissioner Sarmiento and then Justice Carpe Morales.
I don't think it will affect the impeachment trial, the resignation, or a preemptive move on the part of the impeachable officer. Remember that under the Constitution, the Senate has the sole power to try and decide. In other words, it's up to the Senate. It's a political question. And one Supreme Court decision said, because of that sole power, it's hands off for us to interfere. It's purely a political question on the part of the Senate.
Thank you.
The Supreme Court cannot compel the impeachment court to continue being in session and try the second issue, which is perpetual disqualification.
Thank you, Commissioner Sarmiento and Senate President Dillon. Justice Carpe Morales, your views, please.
The question presumes that the resignation is made when trial has already started. Because if not, like the case of Andy Bautista and Mercedes Gutierrez, they were scot-free because I share the consensus that resignation when trial has started would not necessarily call for the dismissal of the articles of impeachment because, as intimated by Senator Drilon, impeachment is not for the protection of the respondent. It's for the prevention of abuses, continuous abuses, and for the protection of the public from being the subject of, call it corruption, bribery, high crimes, although high crimes defies complete definition. Thank you.
Thank you. Prof. Gwen and Prof. Ted, your views, please.
I agree. That particular question is again addressed to the Senate. So the Senate may decide to continue with the trial even though the impeachable officer or the impeached officer, so long as trial has already commenced, even if that official has already resigned. I think even for other public officials and employees, if there's an administrative case that's already pending, it will not be dropped just as a result of a resignation.
Thank you, Prof. Ted.
Concur. I just clarify the administrative aspect of the case. An employee or official may resign if he or she wishes to, but if the employee or official resigns to jump the guns, in other words, aware of the impending filing of a administrative case, even if an administrative case has not been filed, he can still be within the jurisdiction, administrative jurisdiction of whoever is in charge of him or her.
It's a very important.
Just in theory, even if the impeachment court has not been constituted, even if the respondent has resigned, in my view, the impeachment court can still be convened for the purpose of the second issue, perpetual disqualification, because that's jurisdictional, that's within the power of the impeachment court, and therefore it is not academic by the resignation of the respondent before or during or after the trial.
Justice Carpenter Morales.
Senator Drilon, how come you did not carry out that view when you were still an incumbent during?
Because the reality is, after undergoing that trial, it is so tiring that you don't want anymore, to do it. Having sessions morning and afternoon is not easy, especially,
Then let's have senators who are young so that they'll not be enervated.
That's why I'm not running anymore.
As a 10-year-old political nerd, then Senate President Drilon, that was my political awakening, that impeachment trial in 2001. So I think for the information of our audience, the reason why this was brought up was it keeps getting raised in media interviews concerning what happens, can she avoid disqualification? Can the Vice President avoid disqualification if she just resigns? Because the impeachment trial would not proceed anymore. And I think there's some consensus here that there is a second consequence to impeachment, which is not just removal, but also disqualification from office. And a unique feature of that is that, unlike any other penalty in law, that disqualification from office is actually not pardonable. So it's a very high penalty that the Senate can impose as representatives. Professor
I just wanted to say that I'm glad that we're using the word consequence rather than penalty, because in criminal law, a perpetual disqualification is an accessory penalty, but in impeachment, it's not considered as an accessory penalty. It's a consequence of a conviction. So as Senate President Drilon has pointed out, there are two consequences: removal and disqualification. So while the resignation may actually preempt the removal should the conviction happen, the perpetual disqualification remains a live and pending issue. And so should that happen, it should not be treated simply as an accessory to the main penalty or consequence. That's why I don't want to use the word penalty, because it shouldn't be used. Unfortunately, we use the word conviction, which tends to mislead, because if we're thinking criminal law terms, conviction carries a penalty. But it does carry the two consequences, which are separate and distinct. The second point I'd like to make is because carrying out the trial despite resignation of an impeached public official just to determine the disqualification is consistent with the purpose of impeachment, to ensure accountability, because otherwise mootness will just simply sweep that down the road, right? It will just remove every attempt to make a public official accountable. The public official evades the
the removal and also evades the disqualification, while impeachment really is the constitutional last resort for as far as these officials are concerned. The offenses are so grave as to merit impeachment as a way of removing them, and therefore we cannot just simply say by rendering it moot by resignation, even the aspect of whether this person could ever be allowed to hold public office would simply be swept away. So I would support that consensus, but would want to point it out that because of the consequence of just using mootness, we really should disabuse, right, the public of that particular consequence, that it is simply an accessory to removal. It is not. These are two separate and distinct consequences.
The principal consequence of that. If we can move on to the fourth question, just because for the lawyers here, is there a standard of evidence in impeachment trials, or should there be? And the reason why I ask is that in 2012, during the Corona impeachment, one of the key issues raised by then Senator Santiago, Defensor Santiago, was what would be the standard of evidence. Now, for non-lawyers, the standard of evidence is basically how much proof should there be before a particular judgment is given by a court, and in this case, the Senate. Is that question at all relevant? Does it risk the over-legalization of impeachment, and what would be the consequences of that? Commissioner Sarmiento, and then probably Professor Te and Senate President Drilon.
If I recall right, it was an issue during the impeachment of President Estrada. And again, an issue during the impeachment of Chief Justice Corona. What is the quantum of evidence? Should it be proof beyond reasonable doubt or sufficient evidence? Again, to the best of my recollection, it was not proof beyond reasonable doubt, which is very difficult. I think it was sufficient evidence would be enough as guide for the senators in, well, convicting or acquitting the respondent.
Well, I don't think proof beyond reasonable doubt is a standard. That's only for crimes, I think during the time of, during the impeachment of Corona, what was actually followed was overwhelming preponderance of evidence. Preponderance of evidence, in one case it has been said that it's more than 50% chance of getting the desired result. So again, it's because it's the Senate which is given the sole power to come up with its rules. Then we respect whatever burden of proof the Senate will exact from the parties, but certainly not proof beyond reasonable doubt. Thank you.
Senate President Drilon.
Remember that the senator judges are not lawyers. Maybe some are lawyers, some are not. But having said that, there is simply no standard of evidence that is required. Each senator judge would make a judgment on the basis of his or her appreciation. There is no standard that is imposed because it's simply not possible to impose that kind of standard. Because in the first place, we say that the impeachment court is a class of its own. So, from that alone, you can have many consequences. And it's difficult, really difficult to impose any standard because the members of the court are simply politicians in the first place. They are not lawyers in every instance. So it is addressed to their conscience how they would perceive the evidence presented.
Thank you, Senate President Drilon. For Prof. Gwen and Prof. Ted, I wonder if you can tie this question to questioning the question, the larger issue about the way that law and politics interacts in impeachment, because it does look like and feel like a legal proceeding. We call the senators senator judges, there's a prosecution team, there's a defense team, but in the final analysis, it seems like a lot of the rules that we would apply to courts actually do not apply to the Senate. And what would that mean for questions like evidence or burden of proof?
Thanks for that question. The first thing that I'd like to say is that the very first rule under the rules of court regarding evidence is that it applies only for judicial proceedings. So when we talk about evidence, unless the Senate expressly adopts the rules on evidence, which I do not think it should, because as Senate President Drilon pointed out, they are not all lawyers. So, you know, the complicated, technical, nuanced appreciation of evidence may not work for all of the senators who are not lawyers. They are not trained in those rules, and therefore it shouldn't bind them technically. Secondly, because of the political nature of impeachment, I think the standard, and I wouldn't say standard of evidence, the standard, I think, from which any evidence is appreciated by the senators should be, what would I, as a senator, need to be convinced of to remove this elected official from office and bar this official from ever being able to assume office? Whatever that standard is, that should be how the senator views the evidence. Because, again, you know, you can't use preponderance, you can't use a reasonable doubt, you can't use substantial evidence, which is so low a bar in terms of administrative proceedings. And because it's sui generis, as SP Drilon points out, I think the point of view of the senator should be, hearing everything that I've heard, does it convince me, does it answer this question for me, that this impeached official should then be removed from office and should be barred from ever assuming office? And that's a very heavy burden. That's a very difficult question because, again, you're contending with, you know, an elected official who has been put into office by the will of the people, and your vote as a senator is essentially to override that decision of the people, right? In putting that person in office for whatever offenses this person has done, and that has been proven. So I do not think the standard should be the legal standard that we lawyers are used to. I'm trying to recall who it was who said, I think it was Senator Lapid in the Corona impeachment. His explanation of vote was so simple, you know, from the point of view of an ordinary person. You may agree or disagree with his explanation of vote, but that was how he perceived the issue. And so I think from the point of view of the senators, when they're viewing the evidence, they should be viewing it with the end in mind of answering that question. What would convince me that this person should be removed from office, overriding the vote of that this person got, and perpetually barring this person from ever holding any office? Those are two very difficult questions to answer. And maybe just as a third point, Paolo, in relation to the use of evidence, over judicializing the proceedings, right, may also get in the way of impeachment as a mode of truth-telling, of finding out the truth regarding certain transactions, certain grounds. Because again, you know, the litigators know that, you know, one way to get a judgment in your favor is to make sure that the evidence never gets in. So hearsay objections, all of those things, right? But, you know, if for example, the Senate takes on a very, an overly judicial approach towards receiving evidence, right? And therefore, there's hearsay objections all around. Essentially, you don't get to hear what's behind the accusations, right? And so maybe a shift in the mode, right, of adversarial, which we're used to in court, right? People versus X and Y, A versus B, from adversarial to inquisitorial, where the Senate, acting as inquisitors, right, basically try to find out, is this true? And, even if it would be hearsay, right, as long as it is supported by enough corroboration, perhaps the Senate can go beyond that. I say that because of the qualification that the rules of evidence are really for judicial proceedings. They're not really for other types of proceedings.
But the rules of evidence is supplementary to the rules of the impeachment court.
Yes.
And if let's say an objection is raised on that the evidence is hearsay, that can be ruled by non-lawyers. That can be decided by non-lawyers because that is put to a vote in the impeachment court. So, in that sense, the rules of evidence has a supplementary application.
I agree, sir. But what I'm simply, I think, pointing out is that we should not overly judicialize the proceedings. Because I think the other function of impeachment, the trial itself, which sometimes gets overlooked because of the adversarial nature, the perspective that it is adversarial, is the fact-finding, the truth-telling aspect of the impeachment court.
Scholars would actually call it not so much legal accountability, but political accountability.
Yes, political accountability.
And hence the morally coded words of the Constitution on impeachment. Prof. Gwen, before we probably go to the last question.
Maybe just 2 quick points. To the question, I agree with Senate President Drilon. The Constitution does not itself require any standard of proof, nor any quantum of proof in the impeachment trial. And from a practical perspective, I think it will be difficult to impose such a standard because the determination of whether the impeached official's conduct rises to the level of an impeachable offense is addressed to each senator judge. Because at the end of the day, the conviction or the acquittal in an impeachment trial is just a matter of votes. So we look at, so that question is really addressed to each senator judge, and as Senate President Dillon mentioned, not all of them are lawyers. The second point is, while we're discussing burden of proof, I think there are 2 important sort of strands to that question that the Senate should pay attention to. One is their crafting of their rules for the impeachment trial. In the past, I understand that they have adopted the rules of evidence in a supplementary manner. We don't know whether that has affected in any way the capability of a non-lawyer senator judge in receiving information. That's one. The second is if it has affected the capability of parties, for example, the House managers or the House prosecution panel and the defense in terms of presenting information to the Senate for purposes of each judge making that decision. And lastly, also the role of the presiding judge. So in the last 2 impeachment trials, both were lawyers. So Chief Justice Davide and Senate President Juan Ponce Enrile. And you will see in how they've managed, I don't want to say judicialization, but you'll see on one hand how previous experience in running adverse proceedings has helped expedite the proceedings, how quickly they decide on motions. But at the same time, we don't know whether that has in any way disadvantaged those who are senator judges without similar experience. So apart from quantum of proof, and again, I think there really isn't one that we can impose. We should look at the role of the presiding judge and also the manner by which the rules for the trial will be crafted by the Senate.
I think ultimately as well, if we go by the language of the Corona and Estrada impeachments, there was a lot of language pertaining to conscience, whether the conscience of the senator judges would be satisfied by the vote that they would or would have ended up taking. We have just a few minutes for the very last question for this panel, which is very timely in light of events in just the last week when we planned this impeachment forum. There was no case filed yet to the Supreme Court, and now we have two. Right? So if a case is brought to raise these questions, may the Supreme Court step in. And I think, for our audience who may not be lawyers or law students, there's a question there's a difference rather between whether the court can step in and whether the court should step in. May kapangyarihan ba siya o dapat ba siya manghimasok doon sa issue na iyon? So, your thoughts on this, Commissioner Sarmiento?
Address the last question. As of today, the Senate has not been constituted as an impeachment court. So not yet the sole power to try and decide this case. So if addressed that question, may the Supreme Court step in. Now there is this